Welcome to the Rights View channel. I'm Dilip Chakma. Yesterday, hundreds of Adivasi groups supported by Dalit organizations have organized an all-India ban in protest against the Supreme Court judgment that has directed the eviction of over 2 million tribal families whose applications under the Forest Rights Act have been rejected. Today we have Mr. Suhas Chakma, Director of the Rights and Reconciliation Group, to explain the various issues. So Mr. Chakma, could you tell us what is judgment all about?
So the Supreme Court in its judgment had stated that those tribal families or non-tribal families whose applications under the Forest Rights Act had been rejected, they ought to be evicted immediately, and if the eviction process is not undertaken by the state governments, then the court would view it very seriously. So it basically asked the state government to immediately start eviction of over 2 million tribal families whose application had been rejected by the authorities under the Forest Rights Act.
So how do you see the judgment that has ordered the eviction of over 2 million tribal families?
I think the Supreme Court judgment is legally untenable. It's untenable because the Supreme Court at the first instance assumes that once your application has been rejected by the authorities under the Forest Rights Act, you are immediately liable to be declared as a legal encroacher. The fact remains, if your applications under all circumstances is rejected by the forest rights authorities, then you have the right to go to the quasi-judicial institutions like the National Commission for Scheduled Tribes, National Human Rights Commission, and of course if you are unsatisfied with the judgments of these quasi-judicial institutions, you can still go to the High Court or the Civil Court or the Supreme Court of the country. So each and every application which has been rejected by the authorities under the Forest Rights Act is subject to judicial review, and there is no provision in the law, that is the Forest Rights Act, which says that you cannot appeal against the decision of the authorities under the Forest Rights Act. So how and under what circumstances Supreme Court comes to assume that those persons whose application have been rejected ought to be actually evicted without giving them an opportunity of hearing? So that's the first instance. The second instance is, I think the government had rightly said in its affidavit before the Supreme Court that there is no provision in the Forest Rights Act which states that once somebody's application has been rejected by the authorities, to make that person automatically an illegal person or an encroacher. So there is a provision in the law. Third, I think the Supreme Court is completely oblivious to the situation of the implementation of the Act, because under the Act, the authorities which are first adjudicating the applications are the Gram Sabhas, and that's the lowest form of level of the institution we have in a country. So are we expecting that the Gram Sabhas at the lowest level have the competence to actually follow the due process in the consideration of the applications? So therefore I think it doesn't take into the ground realities. And further, when an application under the Forest Rights Act is considered, it's not only the summary rejection of the authorities. Please remember that in many cases the Forest Department is required to provide the map with the GPS indicators, and the Forest Department obviously doesn't do the job, and on various frivolous grounds these applications are actually rejected. So therefore, if we are to look at how the Act is implemented at the local level and why the applications have been rejected by the authorities, I think this is a really injustice to the lowest strata of the society, who have no means to survival, and it is extremely unfortunate. It's not a question of upholding the rule of law. Please uphold the rule of law, but you cannot declare somebody an illegal person to be liable for encroachment until and unless that person has exhausted the entire judicial process, including the Supreme Court. If there is an educated person who lives in a forest area or has lands traditionally from the forest area, he can approach up to the Supreme Court. So why are you saying that he should be evicted at this stage itself?
So what are consequences of the evictions ordered by the Supreme Court?
See, the consequences are very severe. First of all, you are talking about 2 million applications which have been rejected. So 2 million applications basically means 2 million families, and if each family has 6 persons, which is normal in the rural areas, you are talking about 12 million people, and 12 million people is a huge number. If these people are evicted, they have no means of survival. What will they do? They will basically go into the suburbs or the urban areas, and they will become they shall become victims of trafficking, human rights violations, enslavement, contemporary forms of slavery. They will become victims of all the human rights violations one can think of a poor person. So that's one aspect. The second aspect is, if people are actually evicted in this manner, we have seen that one of the reasons why the groups like the Naxalite had made inroads into the tribal areas is because of the atrocities which were committed by the forest department. So in a way, you are creating an environment where possibly groups like the Naxalites will exploit the situation.
So what led to the filing of this complaint in the court?
No, there is a concern among a section of the environmental groups that the implementation of the act shall destroy the environment. People do forget that it is a tribal people who have preserved the environment in the country, and if we are to look at today, the reserve forest or the other kind of forest exist mainly in tribal areas, not in the flat lands where the majority communities are living. And also it arises because of the fact that there is an absence of the rights perspective. So therefore, if you look at the report, The Guardian 2 days back, which had published a report saying that World Wildlife Fund, in the implementation of its program for environmental protection, had actually funded and provided intelligence to the paramilitary troops and paramilitary groups protecting the environment with intelligence input, with the funds, with the weapons, basically to commit serious human rights violation like sexual assault, extrajudicial executions, torture. And the World Wildlife Fund has been forced to order an evaluation into these allegations by a group of human rights experts. So World Wildlife Fund and many of the environmental groups actually do not take the rights-based approach. And if you do not take a rights-based approach, you see it in a black and white situation. You see the fact that tribals whose applications have been rejected actually are illegal encroachers. But I am saying that it is itself illegal simply because you have not given the opportunity to exhaust the entire judicial process up to the Supreme Court. If his or her application has been rejected, and without exhausting or giving them an opportunity to exhaust the entire judicial process, you are saying they are liable to be evicted. So I think there is an absence of rights approach or rights view in the protection of environment, and until and unless this rights view is taken, then there will be serious problems.
Now that the Supreme Court has stayed the evictions it has previously ordered, what is the way out?
See, ideally it should lead to proper implementation of the act, but I do not expect that the government would do anything like that. If you look at the central government's stand, in the last 4 hearings of the case, the central government representatives, but basically the Solicitor General or the Attorney General, did not say a single word. It's only after the eviction order came up, and it will have consequences in the electoral politics in the forthcoming Lok Sabha election, that they decided to go and approach the Supreme Court to modify the order. So the first question would arise, what have you been doing? You were sleeping, that you did not say a word, and these things which you have said in a subsequent application could have been said by the central government in its affidavit itself. And secondly, if you look at the applications which have been rejected by the state governments across the country, there is no concern for the state government to properly implement the act. The government of India, supported by the state government of all parties, have been bringing legislation to deny and deprive and undermine the Forest Rights Act. So I do not see the government is coming up with any kind of ordinance on this issue, simply because the Supreme Court had stayed the order, and they had given them the time till July, to submit the response, and till that time the eviction shall not continue. But I would say that I think thereafter the tribal shall continue to suffer simply because of the extreme poverty, lack of legal awareness, and inability to file a case before the court. And court also assumes that they will not file an application, they have no capacity or whatsoever. So you actually foreclose the right of a tribal to file a petition before the court up to the Supreme Court to adjudicate his or her claim on Forest Rights Act, and that's the reality.
Thank you very much, Mr. Chakma, for joining us and explaining the issue of possible evictions of millions of tribal families in light of the Supreme Court judgment. Thanks everyone for watching. Please subscribe to the show.